All right. Well, hello, everybody, and thanks for joining us for AI in Staffing, Legal Risks and Considerations. I'm Sherry Tischer, and I'm with TCI Business Capital. And for today's webinar, I'm simply just going to be your host. So just to give you a super quick background, prior to joining TCI, I spent 15 years working directly in the staffing industry. And now at TCI Capital, I support and drive our staffing industry practice. We provide funding to staffing owners in the form of invoice financing. And although funding doesn't directly have anything to do with artificial intelligence, we want to be able to provide education and resources to our staffing clients and to our network. So especially on some of these hot topics that we're now seeing in the industry. So that's how we got here today. A couple of quick housekeeping items. We are recording the webinar and we'll send you a link to the recording in a follow-up email. That'll probably come in 1 to 2 business days. And then any questions that you have, certainly put in the Q&A, and Kate and I will keep an eye on that as we go throughout the session. And then for those of you with ASA and NAPS certifications, this webinar does qualify for CE credits. So just to remind everybody about that, but buckle up, let's get started. So I think we can all agree that AI is here to stay, and it's also not a bad thing. I mean, it really can help automate manual tasks. It allows recruiters to work more efficiently. So that's all great. Having said that, it's important to know the risks. So today we're going to talk about these 3 things here up on the screen. We're going to talk about understanding the legal considerations or risks with AI. We're going to talk about analyzing vendors for risks and then strategizing on uses for AI for recruiting. So presenting today's webinar is Kate Bischoff. Now, I describe Kate as fun, engaging, and maybe a bit edgy. Now, yes. She's a self-described, overly enthusiastic, sarcastic, and opinionated management side employment attorney and HR professional. The 3 pillars of her business revolve around training, policy, and investigation. You can read the list of accolades here up on the screen. I mean, the New York Times, CNN.com, Wall Street Journal, the list goes on. They've all recognized her as a leading authority on harassment, tech in the workplace, and employment law. Wow, Kate. Okay, I'm just going to.
Thank you so much. Let me get off this. Let me get off the crazy slide. Okay, yeah. So we're going to talk about AI. AI is one of my favorite topics. And I want to say I'm going to talk a lot about the risks associated with AI today, but this does not mean that there's any prohibition on the use of AI in general. Okay, so there's no rule that says you can't use AI. I just want you to use it very carefully, and that's why we're going to talk about it. So first off, HR tech is a $20 billion industry. So it has a ton of cash. To give you a sense of scale, weight loss is like $5 billion industry. So HR technology is significantly larger than what consumer to consumer business would be. And in that vein, there has been a lot of concern about regulating AI and machine learning. And to that end, in 2020, so in a Trump year, the Congress passed and President Trump signed the National Artificial Intelligence Initiative Act, which defined what AI is for purposes of the law. And this is machine-based system that can, for a given set of human-defined objectives, make predictions, recommendations, or decisions influencing real or virtual environments. So from the law's perspective, that's what AI is. And so I'm going to talk about AI from that perspective. There are lots of things that can be automated, but wouldn't necessarily be considered artificial intelligence. AI is going to affect every single facet of the employee lifecycle, from how you do your sourcing, how you do your recruiting, what onboarding looks like, performance management, offboarding, discipline, all of those things. And there is the potential for some really significant new regulations and laws around this topic. For example, just this week, one of the largest human capital management systems, Workday, was sued by an applicant intending to represent a class of applicants around the concept that he, as a Black man, was discriminated against. The allegations include that the AI used in Workday's applicant tracking system discriminated against him based upon his race and disability, and that the class will be even larger. So while Workday recognizes that they use artificial intelligence in their processes, they deny liability and that they're taking appropriate steps. But this is litigation to watch, and we will see much, much more of this as plaintiff attorneys get more savvy on what AI is and how it works. Okay, so when I'm talking about AI and analytic tools, I want to talk about the 4 big, massive categories that they fall into: text analytics, audio and video analytics, usage analytics, and predictive modeling. Now, when I say text analytics, it's like right now you're seeing AI work on this platform, right? You are seeing closed captioning. There is not someone actually typing in what I'm saying. This is an audio to text analytic where it's listening to me and then it is giving you the words across the bottom of the screen to the best of its ability. Okay. One thing about Microsoft's AI is that they really hate swear words. So if I said the word shit, there's just going to be an extra space there. See, there's the extra space. They're not actually going to translate any swear words that I use. So that is a text and audio analytic. Video analytics can analyze video. Okay, like the zoom in on the crime scene shows that you want, and then the creating the higher resolution. Those are video analytics. We're going to see usage analytics. It's the keyboard watching. How often is somebody typing? How active are they on the actual screen? And then predictive modeling of these are the inputs. This is what we think is going to happen. Okay. Now, while I don't like Tom Cruise at all, there are some movies that reference predictive modeling. My favorite is Captain America, the Winter Soldier, where they can analyze who is going to commit a crime. The Tom Cruise version of this is Minority Report, but they're going to analyze people's backgrounds to determine who's going to commit a crime and then remove them from the population. That is predictive modeling is what they're trying to use there. Don't like Marvel is so good at doing this kind of analysis and predicting what the future is going to be because they're pretty spot on of what it could be in the future. Okay. But today, here are some of the uses. One is recruiting. One is analyzing your candidate pool, finding candidates, and doing background checks. One note about background checks, and I may not mention later, is if you are having a system, go out and find someone and then do an analysis of their background to determine if they're a good fit. That analysis of the background is going to come into conflict with the Fair Credit Reporting Act, otherwise known as FCRA, because you're having a vendor do an analysis of their background, which may include credit reports, criminal stuff like that, okay? Especially if the criminal stuff, FCRA is going to apply. And if you are not getting the sign off from the candidate at the time or before they do that analysis, you probably could be violating FCRA. I expect the FTC to take this very, very seriously and start using their investigative tools to find out which AI is doing background checks before they get the proper check offs. FCRA is so hard to comply with. You have the acknowledgement form. In some states, people get a copy of the report, etc. But if your AI is doing that analysis for you, FCRA is going to be your problem. Okay. The employee, we're determining productivity. There's one system called Occupy, which was stuck on the bottom of a bunch of desks in a newsroom in London. And the journalists figured out what it was. It was there to measure whether or not people were actually at their desks. And they've all of a sudden felt really afraid to go to the bathroom or go do like in-person investigations because they were going to be gone from their desk. The employer was really using this to figure out how many desks do they really need. Can they move to hot desking so that they could reduce their real estate footprint and they wouldn't have to lay anybody off? Because if they reduce their cost of real estate, particularly in London, it would be easier to keep maintaining. But because they didn't communicate that with folks, people were so afraid that if they weren't at their desk, they were going to lose their job, then the analysis was wrong. So we're determining that productivity based upon this tool that measured when people were and predict what could happen there. Okay. Other productivities are the keystroke monitoring and then monitoring for security risks. This is who or what crazy email is Kate getting today that could be a phishing scheme? What crazy text message is Kate getting that could be a competitor trying to sneak? Is Kate emailing herself our trade secrets? The 13 original spices is going to her Gmail account and not staying within the business. Monitoring for those security risks is a really big sector of AI at the moment. Determining potential, whether or not someone is going to be a high potential employee that we could scale up, what skills are they going to be good at. Compensation analysis, we still have a significant wage gap between men and women, particularly women of color. Potential flight risks, who updated their LinkedIn to say that they're open to hire or that kind of thing, or open for new work. You could have an AI system that monitors that LinkedIn to see who is updating their LinkedIn, so you can go do, kind of helicopter parenting to come in to say, hey, please don't leave, that kind of stuff. Succession planning, who looks like they're going to be the next CEO, who looks like they're going to be the new manager, all of those kinds of things. And then last, post-employment. It's how and where employees might be using some of our confidential information. It could be doing network analysis to determine if somebody is talking to a former customer, that violations of a non-solicitation agreement, those kinds of things. All AI can do all of those things. Really cool, right? It might be really, really cool, but we got some issues, okay? So AI typically works based upon math. And it is a big fancy algorithm that can change based upon the data it is given, okay? So if it is machine learning, it changes based upon the data it's given. And what the algorithm does is figure out relationships. Does this correlate with this? One really famous law review article on big data, artificial intelligence, found that when employees read manga, I'm not familiar very well with it, they are much better software developers. So if AI was asking or trying to determine if you are a manga aficionado, that correlation could mean that you're going to be a good coder. Is that really job related? What if everybody who wears purple socks make great nurses? Okay, the purple sock nurses are the best nurses. But I could be a good nurse and not wear purple socks, right? So are these correlations really important to the job? Do they make sense for the job? And those correlations do not always represent, and you'll hear this a ton when you're talking about AI, correlations are not causation. So there is a disconnect there. And under the law, it's causation that we're looking for. Someone who has this skill can do this job. And so we're looking for that job relatedness in causation, not correlation. Then the data that we're feeding it is probably not great, okay? All performance data, okay? Underscore, bold, italicized. All performance data has bias attached to it. So if that's the data you're feeding it, that's going to be biased. There's going to be some potential for discrimination there. They include lots of different biases. We know that as staffing professionals and HR people, when we look at performance reviews, we can see that they're not talking about what happened 9 months ago. They're talking what happened in the last 3 months, because that's what they remember, recency bias. Okay, there's going to be a whole lot of different kinds of bias attached to there. And then the data is often inaccurate, incomplete, and what data scientists call dirty. It takes a lot of time to clean up the data so it can actually be used. And then how do we know what it works, right? If the correlation is purple socks and really good nurses, right? Can we ask the algorithm what those correlations are? Are we going to get to know that? For many vendors, what the correlations are and the algorithm itself is their trade secret. They're not going to be willing to share that information with you. And do we have the ability to test it to see if this really does work or it's really not biased? So these are some of the just functional problems that come up. And then there's this big one around discrimination. How can we verify that it's not biased? Now, I'm going to give you the BS test here for a second. if you're talking to an AI vendor and the AI vendor says there's no possibility for bias because it's just math, they are lying to you or they are dumb. Okay. I want to say that again. They are lying to you or they are dumb, because the math always has some form of bias in it, because the inputs, the data we are giving the algorithm to learn are likely to be biased. The people creating the algorithm are likely to be biased because we're human, we're biased. Okay. I'll give you an example from Nature magazine. Several years ago, they did an analysis of big data, and they wanted the algorithm to go out on the interweb and find a whole bunch of pictures of brides. Okay, so that's what the algorithm did. It went out and found a whole bunch of pictures of brides, all dressed in white. Now, if you are in the Hindu tradition, brides wear red. So the algorithm itself missed that whole section. Approximately a fifth of the world's population are Hindu. They missed that group of people, missed that section of brides, because the people who created it, the data that it was fed, didn't understand that brides in the Hindu religion wear red. Okay, so we have the potential for a whole lot of bias to come in here. Now, the law, while the vendor might not understand that math can always be biased, the law is bad and slow here. Okay, the law, most of the laws we're thinking about when we're talking about AI and what could be applicable are from Title VII of the Civil Rights Act of 1964, the Americans with Disabilities Act that was created in 1990. We're talking about laws that have been on the books for a long time, longer than me in some situations, and I'm going to be 45 next week. Okay, so this is a really big deal. For discrimination, there are two different forms of discrimination that are unlawful. Disparate treatment, which is I am treating you differently based upon the color of your skin, your age, your gender, etc. And then there's disparate impact, where I am not targeting just you, but I have this policy that has a disparate impact on this whole group of people, Hindu brides being the example. Okay, so if the law has those two pieces, how we analyze AI doesn't quite work. And in the end of January, the Equal Employment Opportunity Commission, people responsible for federal discrimination laws, held a hearing about AI. And there was lots of discussion about what is going to be the quote unquote right analysis to determine if the artificial intelligence is actually discriminating. And we don't know what the best analysis is going to be. If we try to pigeonhole in disparate treatment or disparate impact, it doesn't necessarily work quite the way we want it to. So is there another option? This is where the law is slow and we just don't know yet. Okay. Then for AI, we have a huge component of privacy. Okay, because you're taking my data and helping create a system that can make predictions or make decisions about me. Okay, and so that means you have a lot of information. In HR, we have a ton of information about the people that we work with, the employees, the people that we're staffing into organizations. The European Union and California, of course, are leading the way on privacy. If you have not heard of the GDPR before, thank goodness you're in the myopic of just being in the United States. That's really nice for you. But privacy also means that there are laws that are going to allow employees to control their own data. And we'll talk about that a little bit more. But if you're getting private information or about the employee, how much do they know about how you're using that information? And do they give meaningful consent to the use of that information? Knowing where I went to college, what my degree is in, where I live, things that are normally on a resume or on a job application, you can pick out where I am. So for example, I live in the great city of Minneapolis. Minneapolis proper has about 300,000 people who live in it. If you knew that I am a woman, I'm an attorney, and I live in 55419 as my zip code, there are probably 5 women that fit that description in that zip code. So you get pretty close to being able to know that it's me. And did I want to give that information out so that people could determine it was me and be able to find me, etc.? It's really tricky. So does the applicant, the employee, the person we're putting into the staffing, do they understand what they're consenting to give that information? And are there regulations around anonymization? Again, if you anonymize to just say it's a lawyer who lives in 55419 and she's a woman, with those three things, you can pick out it's me. Is it really anonymous? Okay, tricky. So the White House, President Biden, is really concerned about artificial intelligence. He's getting a lot of pressure from several members of Congress, including Representative Ted Lieu, who is actually a software developer, so he understands how AI works. In January, I believe, he wrote an op-ed in the Washington Post about how artificial intelligence really scares the poop out of him. And he's a developer, so he understands the science behind it. And so if we have folks in Congress who don't understand it, do they appreciate the risks that it has? And with a divided Congress right now, don't expect there to be anything that from a congressional level regulating this at this point in time. But needless to say, President Biden issued what's called the Blueprint for an AI Bill of Rights. This is about making systems better for Americans, talking about having safe and effective systems that do what they're meant to do without putting my information at risk, protecting from discrimination, from algorithm discrimination protection, data privacy, making sure I can control my own data and I can control where it goes. Notice and explanations about where the data is going, how it's being used, and what happens when there needs to be a fallback. Okay, what happens when I am requesting to not use the AI? Will employers let me apply for a job without going through the algorithmic tools? Okay, all of those things are part of it. Here's how the Bill of Rights works. It's a two-form test. Again, this is a blueprint. This is not a law. This is what the White House wants to suggest to Congress to make a rule. Okay, so the two-part test is one, it's an automated system that has the potential to meaningfully impact the American public's rights, opportunities, and access to critical resources and services. This includes civil rights, whether this is talking about who gets to vote, who is registered for waste treatment, all of those things. Privacy, whether or not I keep my information secure, equal opportunities, and this is where employers get involved. This is how the Bill of Rights is going to affect us, making sure that discrimination doesn't happen in those algorithms, and folks, the general public, gets access to critical resources. Now, on the privacy part, there is the California Consumer Privacy Act that went into effect a couple of years ago, but employers are now subject to it now. Okay, this is a privacy law designed to give agency, meaning I, the employee, get to control some things. And this includes data collected by employers of employees. Whether you're a staffing agency, that would be the folks that you are placing into other folks, your collection of that data. The employee or applicant gets to know what you're doing with the data. They get to opt out of any sale or sharing of the data. Okay, absent some exceptions, right? Like if you collect the data and then toss it over to the other company so that they can process payroll, et cetera, then of course you're going to have to share it, right? But you have to tell the employee that we're going to share it, that they get to opt out of automated decision-making. Can we do that? They get to ask for things to be corrected if the information is not true. And some of this relates to things that are not AI too. For example, in the great state of Minnesota, if I have a personnel file with you, I get to look at it and I get to add things to it or ask for corrections when I know something in it is wrong. So similar to that is how it will work. The employee or applicant gets to ask for things to be deleted, which has some exceptions again, because, we have statute limitations. And so I'm going to keep your data for as long as I need to under the particular statutes. And then limit the use of sensitive data. For example, I can say to my employer, I'm going to give you my social so that you can process payroll and get me a W-2, but you don't get to use social for any other purpose, which, why would you need that anyway? But that kind of limitation might be really helpful. Okay. Then we have New York City. New York City has an AI and employment new ordinance for folks that requires subject automated employment decision tools, so essentially AI, to do a bias audit within 1 year of its use to make sure that the tool is not resulting in biased decision-making, okay? This ensures that results of the audits are publicly available. You're going to have your analysis of whether or not you're discriminating against people publicly available. Really kind of frightening from an employment lawyer's perspective. And then provide particular notices to job candidates regarding our use of these particular tools. Hey, we're going to use this tool to help figure out who's the best candidate. You got to notify the candidate of that. Allow candidates, employees to potentially request alternate evaluation processes as an accommodation. For example, if you're going to have me do a multiple choice test and I have difficulty reading, I may say, hey, can you read to me the test instead of me reading it myself? Okay, that might be an alternative. Now, this AI in employment was supposed to go into effect this year, January, but the department in New York City that is going to be responsible for it announced that they're delaying enforcement till at least April of 2023. So just a couple months away. I expect that they might need a little additional more time with that because it's hard to figure this out and hard to do. So that's one thing. Now, let me talk to you about an example. Now, this example is from 2017, 2018, so it's not current because why would an employer admit they're currently discriminating against people? Okay, fair. So here's what Amazon did. Amazon is huge into automation. They get thousands of job applicants every month. They want to be able to have something sift through those applications and figure out who should be the best new candidate, the best new manager, quickly, fastly, so they can get people into those jobs. Their, time to hire wants to be as fast as possible so they get the best people. They don't want to have a long, warm bench. They don't want to hold people off for 6 weeks. They want the best people as fast as they can get them. So they created a tool to review resumes, to go through them very fast. And so they created this tool to do it. It would review 100 candidates and spit out the top 5. Okay. So they worked on this for a long time. They got the algorithm, what they thought was just right. And guess what? The tool learned that Amazon prefers men. It learned based on the historical data that they had and how the algorithm worked that Amazon actually preferred men. And they tried to fix this. Okay. So for example, they try to take proxies off of resumes that would suggest someone is a woman. Okay. The women's hockey team, they would just take women's would come off. They would take off gender studies. They would take off volleyball. They would take off a whole bunch of different things that could be proxies for gender. Guess what? Still a problem. The algorithm was still giving them more male candidates than female candidates. So the algorithm was still biased. The result was that they scrapped the program in 2018, and approximately a year later, which is the statute of limitations for employment discrimination claims, not a coincidence there, they explained what they had done and why they had this problem. They are still working on this solution to make sure that it doesn't have gender bias attached to it, as well as all of the other protected classes, but they scrapped this program at the time because they did not want to have a discriminatory result, which kudos for Amazon, really happy that they did that. They were very critical of how their system was working. However, it was still a problem. So if Amazon, with some of the best software developers, the best data scientists out there, is having this problem, it is unlikely that everyone else who has an AI resume reviewer is 100% great, even though this is 3, 4, 5 years later, okay? Some tech company is trying to do this. Some tech company out there is still discriminating against, okay? I want to move on to the next law that is applicable, which is the Illinois AI interview statute, okay? Now, this one's particular, and I will admit there is one vendor out there that I loathe, okay? And I'm going to talk about them in a minute, but this law was created in response to them, okay? So here's what the law does. It notifies applicants that AI will be used in a video interview. Okay. I love video interviews. I love that you get to sit down and ask somebody to respond to some prompted questions over video, because getting a hiring manager to actually let you have time on their calendar to interview and screen a whole bunch of people is really difficult. But if you had video interviews, they could sit down after a long day and watch a few videos with a glass of wine and decide whether or not, or beer, decide whether or not who they wanted to interview on next, okay? It could really streamline the process, okay? Not everybody's comfortable with interviews via video. I get it. There's lots of issues with disability, potentially, etc., and age, but it generally does solve some problems with it. But here's what the law does. You must notify the candidate that AI is going to be used to that video interview. You have to explain to applicants how the AI works and what characteristics the AI will be tracking in relationship to the fitness for the position. Okay, so if it's going to be looking for eye contact, if it's going to be looking for word complexity, if it's going to be looking for word choice, you have to notify the candidate, these are the factors this video interview is looking for. Okay, then you need to obtain the applicant's consent to use the AI to evaluate the candidate. Now, this is an issue. Let me explain why. Does the candidate want to work for you? Of course they do. Why else are they applying for the job? Why else are they going through the nightmare of your applicant tracking system? Okay. Nothing is quote unquote easy to apply. Okay. It is hard. There's lots of drop-down menus, lots of things to fill out. And then you want a copy of my cover letter, all that kind of stuff. If they're showing an interest in your job, they want the job. So are they just clicking through the consent? Probably. Do they understand what they're clicking and giving away with that consent? Probably not. Because when I get a new app on my phone, I just want to get to the app. I don't read all the messages, or when there's an update. Sometimes I just for fun, I email it to myself, but I don't actually read it, right? Then the law says you can only share the video interview with those who have AI expertise needed to evaluate the candidate and must otherwise keep the video confidential. That means who is getting the video, likely a hiring manager, needs to understand how the AI works and how much credence to give the AI. Okay, this is important. And then the employers must comply with an applicant's request to destroy their video interview within 30 days. Okay, again, if I am an AI video interviewing platform vendor, I want all those videos because all of those videos help improve my algorithm. So do I just not go to the state of Illinois? Maybe. Here's why this law exists. It is the folks at HireVue. Okay, HireVue is a video interviewing platform that up until 2020, I believe, had an AI analysis overlay over the video interview. Okay, what it did is it used the AI to conduct an analysis on the video themselves. It will look at word choice, word complexity, facial expressions, eye contact, all used to determine who is the best candidate for a particular position. Okay, you all seeing where I'm going here? The analysis would give you a 5-star rating, or that's how the system worked initially, that it would give you the candidate would be 1 star or 5-star. It was kind of like the Netflix of candidates, right? Like, ooh, this one's recommended for you because they did really well. Now, let's give you a hypothetical. Let's say I have Bell's palsy, which temporarily paralyzes a portion of my face, okay? If you are using HireVue's Insights program, which is this AI system, it is looking at my facial analysis to evaluate whether or not I am excited about this position. But if half of my face is paralyzed, the analysis is going to be wrong. If I'm blind, it is not reading my eye contact with the camera, okay? Because I'm not making eye contact with the camera. I'm blind. If I am a new English language speaker, okay? If I am brand new to this, I would be a great laborer for you. I would be a great nurse for you. But my vocabulary is limited, my word complexity is limited. Then the result of giving me only 1 star because my word complexity and word choice was small is going to lead to a discriminatory result. I'm not going to get the job because of that. Okay. So they did an independent analysis. They had a people who came in and did the analysis, and they found out, oh my God, it resulted in discriminatory results. The analysis had preference for white candidates, white American candidates, and folks without disabilities. So they looked at it and they found that they were discriminating against. Similar to what happened before, they announced that they were turning off this program because of the discrimination that resulted, but they waited a year until they turned it off, and they waited a year before they announced why they turned it off. Because again, the statute of limitations for this is 1 year in most states. Some states don't have a related state entity, so then it could be just 180 days for discrimination, but in many states, it's a 365 days statute of limitations. So what HireVue did, discovered that they were discriminating, turned off the system, and then waited a year to explain so that they could not get in trouble with their clients. Pretty sneaky, right? Okay. In response to all this stuff that's been going on, the EEOC has issued new guidance on the use of algorithms and artificial intelligence to assess job applicants with an eye towards the Americans with Disabilities Act, that analysis of whether or not I'm blind and making the eye contact. This guidance from the EEOC is helpful, but it doesn't answer all of the concerns we have and doesn't answer some of the legal pitfalls that exist because the law is antiquated here and cannot keep up with the rate of technology. So we have some guidance from the EEOC. The hearing from January of this year will be helpful in creating new guidance, but we're down a commissioner. There's only 4 of them at the moment. Apparently they're fighting constantly. And so I don't expect to get much guidance from the EEOC anytime soon. We should have a better comprised commission, but that depends on how fast the Senate can confirm confirm nominations to the EEOC. So we just don't know. So very few folks have the resources of Amazon to be able to create the algorithms themselves. So most of the time, an employer, a staffing agency or whatever is using a vendor to help them. Okay. You are going out and you are buying something from a HireVue. You are buying something from a Workday. You are buying from a vendor to help you use AI to improve your processes and get better candidates, all those fancy languages into your system. But there's a lot of risk associated with that. I want you to note, if this is the only thing you take from today's webinar, I want it to be this. The employer is always liable for employment decisions. Very rarely could a vendor be held liable for these things, okay? The employer is always liable, not always the vendor, okay? Hopefully that is raising some alarm bells with you because you often are relying upon your vendor for compliance purposes. You are relying upon your HCM to be able to poop out your EEO-1 form. You are relying on them to help you do analysis to find out if there's a disparate impact for your layoff, okay? They may be giving you information, but the decisions you make from that information are still yours. So even though HireVue was facilitating discrimination against individuals with disabilities, that was always the employer's fault, not the vendor's fault, okay? Ready? It's always the employer's fault, not the vendor's fault. Very rarely can the vendor actually be sued under the statutes directly, okay? So here's some questions I want you to ask a vendor. 1, has the process demonstrated an adverse impact? This should raise alarm bells with them that you know what you're talking about and that you want for them to verify that there is no disparate impact on any protected classes here, okay? Systems exist, including adversarial bias systems that test algorithms to make sure that there isn't a bias result. Those all exist out there. So if your vendor can show you that they're doing that analysis, feel better about it. If they have no idea what you're talking about, move on. Okay. What validation evidence have they been collected to establish the job relatedness of the algorithm? Okay. So if the algorithm finds purple wearing socks make the best nurses, how do you know that that makes the best nurses? Is that really job related? And are they doing it for every position you're looking for? Under the uniform guidelines for employee selection programs, what's called the UGISP, you might be more familiar with it by the 4/5 or the 80-20 rule. UGISP requires job relatedness and business necessity. Okay, under those are the only factors you can use in making business decisions, not whether or not they're wearing purple socks. So you want to ask your vendor, what validation evidence are they using in their correlations for each position? And they should be able to tell you that. They don't need to tell you necessarily what the weight is for each factor. That's likely to be their trade secret, but they should be able to tell you what the correlations are and the validation evidence to support those correlations. Does the validation evidence comply with the uniform guidelines for employee selection programs? And get a copy of the validation study. If you're in New York at all, you're going to have to be able to do this analysis in a year from April 2023. So they should already be able to be prepared with the validation study in the first place. Do they have that adverse bias mechanism to test for bias? Are they constantly determining if there's bias in the first place? What kind of data security do they have? Do they have some sort so that your employee information cannot be shared? For example, we have several lawsuits out there right now with HCM systems, including the Kronos program that was used by PF Chang's. PF Chang's is suing Kronos for their sharing of information. Yeah, really? Craziness. Okay. What's their level of data security? Do they have data security professionals? Are they following the ISO standards that exist for that, etc.? If the information or employee information is anonymized, how is it anonymized? How is it worked? How can we make sure that our employee information is not identifiable, even though that might be really hard? What kind of ongoing monitoring do they provide? Do they continue using it? Now, I want to give you one other hypothetical. Let's say I get hired on March 10th, 2023. I apply. I don't get hired for the job. A white man does get hired for the job. Okay. Within 180 days or 365 days, I can sue alleging gender discrimination. Okay. If the vendor system that was in place on March 10th helped weed me out of the system, is the vendor going to be able to go back and say, this is the algorithm we used on March 10th, even when it's a year later? That can be really tricky because most of these systems are going to be what's called machine learning. So the algorithms are constantly going to be changing. The vendor, per some contract terms that you're going to be asking for, needs to keep every copy of the algorithm in case we get sued based on that particular copy of the algorithm. So what kind of monitoring are they doing? And are they keeping any of this stuff? Because when we contract with them, we need them to do some training, to train our managers on what the potential, how to use the system under both the New York City ordinance, as well as we want them to be able to properly weight what information they're getting from the algorithm, right? If it's a 5-star rating, some hiring manager, and you all know them, are going to be lazy and they're just going to hire all the 5 stars without doing any analysis themselves. That's why we need the vendor to come in and train the people about why that might not be the best way to go about. Okay. It is when we get sued, are they going to produce the algorithm that I was abused on my data on March 10th? Are they going to be able to share that information with me? Are they going to be willing to share it with an agency? Okay. And are they going to be asking me to protect them if I get sued? So I have to pay their attorney's fees. I have to pay for their production of all those things. Those will be indemnification clauses. If you can avoid them, please avoid them. Some vendors are really not helpful with this and demand an indemnification language for their own product. That seems silly. I don't indemnify my car manufacturer if they have a defect in the car, right? That's their problem. Software right now has lots of these indemnification clauses out there that can harm me as the employer, but why wouldn't in the world would I want to protect that? So be mindful of these indemnification clauses. What must we do right now with AI, whether it is using ChatGPT to create a job description or a vacancy announcement? We need to understand what privacy and bias concerns are out there about this particular AI system. Okay, we need to think critically about the tool we use, go through those vendor questions, ask, or do these things exist? And evaluate the tool for usefulness. Some vendors are out there saying, we're going to give you the best candidates with 90% accuracy and 90% usefulness. Well, do you have a comparator client to me? Can you prove it? Then you need to train managers on how to not rely solely on what the AI is telling them and hold tool creator accountable. If a vendor is giving you a system that means that you're only hiring Black people and you're discriminating against white, Latino, and Asian people, no, they need to make sure that they're not discriminating against, and they need to be monitoring. You want to ask them for how they're monitoring and ask that regularly. Don't just sign the contract and then it's going to be okay. No. This is kind of a constant conversation you want to be having with your vendor. Okay, so I am ready for questions when you are. I know AI is coming in lots of ways. It is already here. And there are going to be more laws and more regulation about that. I am in close contact with one legislator here in the state of Minnesota who has put on her to-do list looking into what artificial intelligence systems and what kind of regulations should she request there to be legislation on. So it's coming. It's going to be a really, really big deal. So assess where you are right now. What data do you and or your vendor have? How are you actually using it? And does it have any of the concerns about privacy and discrimination that could exist? Are you using any AI right this second? AI, because of ChatGPT, has been given a huge spotlight recently, which is a great one. This is good. And we always clean things up and make problems go away by putting a spotlight on them, right? That's how we solve these things. So we need to determine what we're using and whether or not we're compliant at this point in time. But remember, the employer is always responsible for employment decisions, not the vendor. Okay, so Sherry, did I spark any questions from you?
Well, I think the ChatGPT thing was the thing that I was going to ask about, if not brought up. So thank you for bringing that up. And we are out of time. So respecting everybody's schedules for today, I just want to thank you, Kate, for doing this for us. And thank everybody for joining. I do have our contact information up on the screen here. You can scan those LinkedIn codes if you want to connect with either Kate or I. I can help obviously with anything staffing related or funding related. And then Kate, obviously employment law and HR tech. But there will be a survey that comes up after the webinar. And one of the questions is related to additional topics that TCI can bring forward and share with our network. So certainly we appreciate people entering comments in there. And have a great day, everybody.